Hi folks, welcome to SQE1 window. In chapter 7, we explore leasehold titles. So a lease is a contract granting a tenant the right to use property in exchange for rent. The landlord retains ownership and can enforce lease terms against the tenant and successors. Leasehold is one of the two legal estates under Section 1, Subsection 1 of Law of Property Act 1925, alongside the fee simple absolute in possession that we commonly know as freehold. So to start with, landlord-tenant relationship, the landlord-tenant create ongoing obligation and rights between the parties. Like through lease, they create rights. So understanding the terminology and structure is fundamental. The lessor or landlord retains the reversionary interest. This means ownership reverts to the landlord when the lease ends. During the lease term, the landlord enforces covenants, collects rent, and maintains the reversionary interest. At least, it got certain control over property. At lease expiry, once it expires, the landlord regains full possession and control. So leasehold creates a hierarchy of interest. In the simplest case, a freehold grants a lease. The tenant holds the leasehold estate and is bound by the landlord's covenants, promises, in simple terms. But leasehold interests can be more complex. A tenant under a lease can themselves grant a lease to another person. This creates a sublease. The original tenant becomes both tenant to their landlord and landlord to their subtenants. They are sometimes called the intermediate landlord. You can just understand it. The subtenant is bound by covenants in both the head lease and the sublease. Restriction in the head lease flow down. If the head lease prohibits commercial use, the sublease cannot permit it. This hierarchy can extend through multiple levels, creating chains of landlord-tenant relationship. So understanding this structure is very, very important to just look at. Like hopefully you understand it from freehold, it goes to leasehold. Freeholder got reversionary in right, like it will come back to them. A leaseholder, because it is an estate, can further lease it and become a sub-landlord within leases. So the next thing is a transfer of lease, assignment versus subletting. Tenants have two main ways to transfer their interest, assignment and subletting. The distinction is very important. Assignment transfers the tenant's entire remaining interest to the assignee. The assignee steps into the tenant's shoe, becoming the new tenant under the lease. The original tenant typically drops out of the landlord-tenant relationship, though they may remain liable under certain circumstances. Subletting creates a new lease, and that new lease is carved out of the tenant's existing lease. The tenant grants a lease to the subtenant but remains the tenant under the original lease. They become landlord to the subtenant while remaining tenant to their own landlord. So the crucial rule from Wilson's case from 1868 is that a sublease must be shorter than the tenant's remaining lease term. For example, I got like 99 years lease. I cannot grant 100 years lease on that one. You cannot grant a sublease for the full remaining term. That would be assignment, not subletting. Most leases require landlord's consent for both assignment and subletting. The nature of consent requirement varies and significantly affects the tenant's freedom to deal with lease. We shall examine it later. Like another distinction is lease versus license. So this is very important. The distinction determines whether a proprietary interest exists and what protection apply. A license is mere personal permission to occupy or use property. It creates no proprietary interest in the land. It's not enforceable against third parties who acquire the property. The license has contractual rights against the licensor, but no rights in the land itself. For example, Airbnb, you go and live there. At that point, It's a license, it's not a lease there. A lease creates a legal interest in land. A term of years absolute. It's enforceable against the will. Subject to registration requirement, leases attract substantial statutory protection, particularly for residential tenants. The key test for distinguishes leases from license is exclusive possession, which was defined in Street versus Montford. Does the occupier have the right to exclude other, including the owner, from the property? If yes, it's a lease. If the owner retains control or access, it may be licensed. For example, part of the property is licensed at that point. So leading case is Street versus Montford, once again from 1985. In that it was held that exclusive possession for a term at a rent creates a tenancy. Regardless of how the parties label it, calling an agreement as a license will not make it a license if all criteria of lease is fulfilled. Courts look at substance, not form. If the arrangement gives exclusive possession, courts will find a lease even if the document says license. This prevents landlords from avoiding statutory protection by relabeling leases as licenses at that point. So exclusive possession alone is not always decisive. In family arrangement, acts of friendship or service, occupancies, exclusive possession may exist without creating a tenancy. So context does matter. For example, you rent a room at a hotel, at that point it will not create a lease for you, although you can exclude people from your room. So you need to understand the context. So there are different type of tenancies. In English land law, a tenancy at will exists where the tenant occupies the landlord's permission, but with no fixed term. So there is no fixed term. There is occupation of the property. Either party can terminate at any time. No written agreement is required. These arise informally but create certain rights between peoples. Number 2 is periodic tenancy runs for successive period, weekly, monthly, yearly, and automatically it renews unless terminated by notice. Periodic tenancies commonly arise when tenants remain in occupation after a fixed term lease expires and continue paying the rent at that point. Monthly, it is going periodic at that point. A tenancy at sufferance occurs when a tenant remains in possession after their lease expires without the landlord's consent, but without the landlord's taking action to remove them. That lease ended, but you are still in the property. The tenant has no right to be there, but is not a trespasser. The landlord can terminate this at any time. The tenancy by estoppel arises where a landlord without a title grants a lease. Title is not in your hand, but you control something and you grant a lease. Normally, you cannot grant more than what you got, but if the landlord later acquires title, the lease becomes valid by operation of estoppel. The tenant cannot deny the landlord's title, and the landlord cannot deny granting the lease in this case. So the next thing is creation of lease and formalities. So we got two different kind of leases, like it is legal leases and equitable leases. We will be talking about it. So a legal lease must be a term of years absolute. It does not mean it must be years. It means specific term or time that can be defined. For leases exceeding 3 years, a deed is required. Under Section 52 of Law of Property Act 1925, without a deed, you have only equitable lease at best. The exception is parole leases, oral or informal leases for 3 years or less, taking effect in possession at the best rent reasonably obtainable without a fine. These are legal even without writing. Under Section 54(2), if it is less than 3 years, you can do it orally at that point. You don't need a deed to write. If it is more than 3 years, you need it. Equitable leases arise when legal formalities are not met but a valid contract exists. Section 2 of Law of Property Act, like miscellaneous provisions 1989, require contracts for land disposition to be in writing, incorporate all terms, and be signed by both parties. If these requirements are satisfied, equity treats the contract as creating an equitable lease under the doctrine of Walsh versus Lonsdale. So registration requirements differ by lease length. Lease exceeding 7 years require substantive registration. They must be registered with their own title. Leases of 7 years or less may be protected by notice on the superior title, but don't require their own registration. Very short leases may be overriding interest, for example, 1 year, 6 months, 1.5 years. So for SQE1, remember the formality requirement: deed for lease over 3 years, parallel exception for 3 years or less at market rent, and then written contract for equitable leases. So the next thing is best practices that we got for commercial leases. So we got Code of Leasing Business Premises, and that provides best practice guidance for commercial leases, though it is not legally binding. But Part 1 requires pre-letting transparency. Landlord should provide clear information about lease terms, including rent, service charges, and other costs before negotiation. So this helps tenants make informed decisions. Part 2 provides lease negotiation guidance. It recommends fair allocation of responsibilities between landlord and tenant. Repair obligations should be appropriate to the lease term. Shorter leases should not impose full repairing obligations that ignores the property's age and condition. Part 3 offers template heads of terms and a checklist, like a standardized negotiation, and ensure key issues are addressed. Part 4 provides detailed guidance for both landlord and tenant on specific lease terms and their implications. So the code is to ensure transparency, fairness, and appropriate allocation of risk, while non-mandatory, like it represents industry best practices by RICS, and those are followed in commercial leases. So repair obligations. Who will repair the property? So repair obligations are among the most important and frequently disputed lease covenants. At common law, there is no implied covenant that landlord will repair unless statute imposes one. For residential leases, statutory obligation apply. For commercial leases, everything depends on express covenant. A tenant covenant to keep premise in repair, as established in Haynes' case in 1847, requires the tenant to maintain the property and return it in repair at lease end. This can impose substantial obligations, particularly for older properties. A schedule of condition limits tenant's obligation by recording that property's condition at lease commencement, that everything is recorded. It happens in residential as well. They give you kind of like, I don't know, like, you know, at start you have pictures and a big report about the property. So the tenant need only return the property in no worse condition than documented. This is common in commercial leases, particularly shorter term, where full repairing obligation would be unfair. So we got another clause that is called Yavier versus Harris clause. Allows landlord to enter premises, carry out repair if tenant failed to do so, and recover cost from tenant. This gives landlord a remedy without needing to forfeit or sue the tenant. Come in, repair, and go away. And that's what is tested in SQE sometimes. So the extent of repair obligation depends heavily on the lease wording. Good repair differ from substantial repair. So reference to age and condition may limit obligations. Courts interpret repair covenant contextually, considering the property type and lease terms. Another thing that is protecting property and payment, insurance and rent. So those are very, very important. In the lease, building insurance is typically the landlord's responsibility, with premiums recoverable from tenants. The lease should specify who insures, what's covered, and how premiums are divided at that point. Landlords usually insure because they have an insurable interest in the rebellion and want to control insurance quality. In commercial leases, rent usually continues despite insured damage. If fire destroys the building, tenants remain liable for rent unless the lease contains a rent suspension clause. Such clauses suspend rent if premise becomes unusable due to insured risk. They are standard in modern commercial leases. Rent includes not just the basic rent, but potentially ground rent, premiums paid on grants, insurance reimbursements, and service charges. All of it becomes rent. Understanding what constitutes rent matters for remedies. Landlord can forfeit for rent areas, but different procedure apply at that point. Residential and commercial leases differ significantly in rent obligation and payment terms. Residential tenancies often have rent control or limits. Commercial rents are typically subject only to market forces and negotiation between parties. So, rent review and service charges we will try to look at. Rent review provision allow periodic rent adjustment, typically every 3 to 5 years. In commercial leases, review may be upward only, which is standard for commercial leases, or upward and downward. So disregard clauses are crucial. These clauses, these exclude like certain factors when assessing market rent. Typically, tenants' improvement are disregarded. The rent should not reflect value added by tenants' work. The tenant's occupation may be disregarded, assuming the property is vacant. These clauses prevent tenants from being penalized for improving the property or from receiving credit for their own occupation at that point if the property has gone very popular. So service charges require tenants to reimburse landlord for maintaining common areas, providing services, and managing the building. In multi-let properties, service charges fund shared facilities, lifts and all of it, security, cleaning, repair of common parts. For residential leases, Section 19 and 20 of Landlord and Tenant Act 1985 provide statutory protection. Service charges must be reasonable and major works require consultation. The residential regime heavily regulates service charges to prevent abuse. For commercial leases, the RICS service charge code provides guidance but is not mandatory. So commercial tenants have fewer statutory protection and must rely on lease terms and common law reasonableness. So understanding service charge provision is essential for advising on lease obligation and disputes. So the next thing is Equality Act 2010, my favorite, protects at least people who came to this country to have some good life. So Equality Act 2010 imposes important obligation on landlord and property managers. Section 35 prohibits discrimination in property management. Landlord cannot discriminate on protected characteristics, including disability, race, religion, sex, or sexual orientation when granting leases, managing properties, or providing services to tenants. Reasonable adjustment for disabled people are required. This includes permitting assistance animals, for example, a dog, guide dog. Even in leases prohibiting pets, like at that point, a guide dog will be okay. And landlords will need to allow adapted fixture like grab rails or ramps, and permitting furniture changes to accommodate disabilities. So structural alteration generally are not required. Landlord need not make major building modification, but minor adjustment that don't prejudice the landlord at that point. So the reasonableness test consider factors including adjustment effectiveness in overcoming disadvantage, its practicality, cost and impact on the landlord and other tenants. Not all requests must be granted, but landlord must consider them seriously. So failure to make reasonable adjustment constitutes discrimination and expose landlord to claims. So the next thing is alienation and alteration. Tenants try to deal with the lease at that point. Alienation refers to tenants' ability to transfer or charge their lease interest. This includes assignment, subletting, licensing others to use the property and charging the lease as security. Leases typically contain alienation covenants restricting these rights. Three types exist. Absolute covenant prohibits alienation entirely. The tenant cannot assign or sublet under any circumstances. These are rare and, of course, those are harsh. Qualified covenant require landlord consent but impose no standard. The landlord can refuse for any reason or no reason. These give landlord substantial control. Fully qualified covenant require landlord's consent, which must be not unreasonably withheld. Section 19, subsection 1A of the Landlord and Tenant Act 1927 implies this reasonableness standard into qualified covenant for alienation. Landlords must have legitimate reasons for refusing consent. So alteration covenants restrict tenants' modification. The distinction between structural and non-structural alteration matters. Structural changes affect the building integrity and non-structural changes are cosmetic or internal. So Section 19 of Landlord and Tenant Act applies to qualified tenants. Again, improvement. For improvement, landlord cannot unreasonably refuse consent, though they may require condition including reinstatement at lease end. So understanding alienation and alteration provision is crucial, and also all these different you can say types of covenants. It can be absolute, qualified, fully qualified, and all of it. You need to understand them in your exam. So proper use and protection. Use covenants restrict how tenants may use premises. Commercial leases especially specify permitted use precisely, such as office use only, retail use with Class E. This protects landlord's interest and other tenants in multi-let properties. Landlords have three key implied covenants. First, quiet enjoyment. The landlord must not substantially interfere with the tenant's use and enjoyment. This does not mean silence, it means freedom from interference. Second, not to derogate from grant. The landlord cannot undermine the purpose for which the lease was granted. Third, for residential leases, Section 9A of Landlord and Tenant Act implies a covenant that premises are fit for habitation, that people can live in it at least. So tenants have several implied covenants. They must pay rent when due. They must avoid waste, not damage the property. They must allow the landlord access to view the state of repair and carry out landlord's repairs. They must not use the property illegally. These implied terms operate unless excluded or modified by express terms. Modern leases typically contain detailed, express covenants that supplement or replace implied terms. So at that point, it helps both. So our favorite exam tips: first and crucially, distinguish lease from license. Exclusive possession from Street versus Montford. Second, identify types of tenancies, their characteristic. Is it fixed term, periodic? Is it any other type of tenancy? Those work different. Third, understand landlord and tenant covenant thoroughly. Repair obligation are frequently tested. Know the difference between keeping in repair, putting into repair, and fair wear and tear. All of it you need to understand. Fourth, know the rules on alienation. Distinguish absolute, qualified, and fully qualified covenants. All of it. Fifth, understand alteration provision, structural versus non-structural alterations. 6, be familiar with statutory protection. So Landlord and Tenant Act provides crucial protection for residential tenants. So what are the protections and how Equality Act 2010 protects leaseholders or tenants? 7th, understand the code of leasing business premises. So that's very important. Another thing, we need to understand assignment and at that point subletting and all of it. This will help you a lot. I wish you all the best. If you like our session, you subscribe please and share it with your friends. Ta-ra for today.